It's WPSD Local 6 Legal Line on this Thursday, along with Austin Kennedy of the Bryant Law Center in Paducah. Have a question about personal injury. We'll entertain those questions at 1-888-208-6946. And we have a question from Jimmy who says, I had a car wreck last year. How long do I have to file a claim?
Well, Jimmy, it depends on where the accident happened. If it happened in Kentucky, it's a 2-year statute of limitations. That's 2 years from the date of the accident or 2 years from the date of the last PIP payment, whichever is later. So you can go beyond the 2 years in Kentucky potentially. In Illinois, it's a strict 2 years. There's no extension for PIP payments. Tennessee is a strict 1-year statute. So it makes it very difficult to, I guess, maintain a case. You need to contact a lawyer as soon as possible to make sure that that they take the right steps to assert your claim, and if necessary, to file the case in the right jurisdiction. So I would say if you had an accident a year ago, again, depends on which state it was in, but the sooner you contact a lawyer, the sooner they can get to working on it.
We have a question from Wendy who says she was running an errand for her employer, was involved in a car accident, did have injuries. Would those injuries qualify for workers' comp?
Yes, more than likely. If you were injured on the job in the course and scope of your employment, it would be covered under workers' compensation. You could potentially have a liability claim if you were injured and it was not your fault, say it was the fault of another driver. You could actually have 2 claims potentially. There would be the work comp and the liability claim. The statute of limitations on both those are going to be 2 years. And how that would work is that work comp is primary, meaning they are going to pay on your medical bills. Instead of PIP, like in Kentucky, you would have all your medical bills would be going to work comp. They would also pay your wage loss, which would be called temporary total disability. It's 2/3 of your average weekly wage as long as you were off work per doctor's orders. You could get additional wage loss through the PIP if it does not fully compensate you. But again, that's one of those, if you were injured and it was, whether it was due to someone else's fault or not, you still have the work comp claim, and if it was due to someone else's fault, then you would have both the work comp and a bodily injury liability claim against the at-fault driver and his or her insurance.
I think one thing is, as I talk to you all month to month to month, no personal injury claim, no two are alike. They're sort of like snowflakes. Everything has their own individual twists and turns, which is why you do need to contact a lawyer. But if you do have a question, 1-888-208-6946. We'll get that in before we get out of here in a couple of minutes or so. Marco, you're up next. He has a pre-existing back injury. Got in a car wreck last month. Will that pre-existing injury hurt his case?
Not necessarily hurt the case. Again, like you just said, every case is different. The fact that you had a back injury in Kentucky, you usually take the plaintiff as he or she was the time of the accident. If you just had surgery or an MRI done and it showed what the injury was prior to the accident, that's good evidence, because then if you have the MRI or X-ray after the accident, you can compare the two and determine whether or not it was an aggravation, whether it was something that was pre-existing, whether it was a completely new injury, altogether. There's just different things that come into play there. I would say the medical proof is going to be vital in a case like that. Getting doctors' opinions and reports to put down in writing, or to maybe have depositions where they can testify on their medical opinions, whether or not this injury was an aggravation, a new injury, or something different.
Our final question comes from Jenny, whose son still lives at home with them, is 18, had a car wreck in his car. Can the other party involved take legal steps against them, his parents?
Well, how that would work is it would be potentially a claim against the insurance of the vehicle your son was in. If it was a household policy, say it was owned by you or your husband or wife, then the only claim that would be made would be against the insurance company. If a lawsuit had to be filed, unless you gave your car to your kid and he was not, say he was under the influence of alcohol or something. Obviously something like that could potentially lead you to being liable, but for the most part, in the majority of cases, it's just to be a claim against the insurance company and no one else.
Austin Kennedy of the Bryant Law Center has been our guest on this edition of Local 6 Legal Line.